oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5007, Brett Steele, appellant, versus Lloyd J. Austin III in his official capacity as Secretary of Defense. Ms. Rucker for the appellant, Ms. Lyons for the appellate.
Good morning, counsel. Ms. Rucker, please proceed when you're ready. Ms. Rucker, can you hear us? Oh, can you hear us now? Okay, please proceed when you're ready, Ms. Rucker.
Thank you, Your Honors. Good morning, Your Honors. May it please the court. I am Donna Rucker, and I'm here on behalf of Dr. Brett Steele. And we have brought this appeal because we believe that the trial court, in presenting its findings of facts and conclusions of law, can be reversed under the circumstances in this record, even under the deferential standard, because it's clearly erroneous. And we also believe that Dr. Steele proved that but for his age, he would not have been issued the termination notice in this particular case. As the court knows, one way of showing the clear error standard is to show that the lower court ignored evidence that contradicts its credibility assessments. We're clearly not saying here that credibility assessment, making credibility assessments was not something that the court could do. What we are saying is that in this particular case, the court erred because it is not well grounded in fact and law, or logic rather, in terms of what the findings of facts and conclusions of law offered. It ignored contrary evidence, and it took positions that were illogical and implausible, and it rested upon internally inconsistent reasoning. And with those facts or the factors proven, this court may reverse even under the deferential standard of review. So specifically with respect to not well grounded in fact and logic, when you look
Ms. Rucker, excuse me if I may, just before you get into your arguments based on the findings and the evidence, in terms of the standard, the standard for liability, you know, there's the but-for standard for full relief and the a factor standard for only forward-looking relief. And I take your case to be invoking the but-for standard and not in the alternative, the a factor standard. That's how the case was tried, and that's how your appeal brief and particularly the reply brief clarifies. It's just to confirm that's correct.
That is confirmed, Your Honor. And in mentioning the issue of it is tainted, we do understand the court did not have to reach that given the position that we took in presenting our case. But it clearly shows that from this record, there were considerations. But the judge, of course, was looking at the but-for standard. So when we look at the fact that this was not well grounded in fact and logic, we must turn to Colonel Bell. And Colonel Bell offered during the course of this trial a lot of information pertaining to budgets, budget cuts, state versus DOD across the board budget cuts, and pontificated and offered that this is now why Dr. Steele had to be released. But we cannot ignore the record in this case, and we should not, excuse me, because when you look at Colonel Bell, he says specifically on this record that when he made the decision to release Dr. Steele, he did so in reliance on the academic leadership. And so what is the significance of that? Well, if you're relying on the academic leadership, we have to look at who that is. And in this particular case, that would be Dr. Bolanos and Dean Hanlon. And so when we look at what has been offered and rationalized in this particular record, which is the wonderful recitation of the budget situations, what had to happen and what needed to occur, we cannot overlook the fact that that is Colonel Bell offering that allegedly as to what he did in making this decision. But he clearly relied on academia. And so what happens next is during the course of this case, there is an effort to argue and therefore withdraw Dr. Bolanos, who is Dr. Steele's first line supervisor, from the discussions and considerations regarding whether to fire him. it is illogical. Even though we know on this record, Dr. Bolanos says, I didn't have any involvement. What contradicted that is that at the administrative level, she indicates that there was an involvement in the decision to fire. And what Judge Mehta does, the lower court does, is simply says, I don't find that to have impacted or affected her credibility in this particular case. That those statements do not have the ability or didn't have the effect of reducing his credibility assessment of her. However, in this particular case, there's also much talk about Dr. Steele not being found to be credible because he allegedly embellished his testimony. However, this record shows that Dr. Steele specifically indicated during the administrative record in this case, as well as during the deposition that was held in this case, he referenced the fact that there was this African-American woman who had brought a race discrimination case, and that she ended up having to be brought back was brought back because of a EEO complaint or something of the sort filed. So it isn't correct that he embellished and mentioned for the quote first time these things. There is also in his deposition testimony where he is being questioned, he clearly talks about Dr. Bolanos referring to older people as cantankerous. And so it isn't so that there was an embellishment. And even to the extent that the lower court wanted to conclude that there was some embellishment. How do you disregard and find overall Dr. Steele, who has been litigating this case for years, somehow or another was not truthful about anything that Dr. Bolanos said? Most importantly, when you look at this analysis of the alleged embellishment, what you also see is that you don't have that same analysis when you look at incorrect statements or impeachment scenarios of the other witnesses. It's simply, yes, they were impeached, but I don't find that affected their credibility. But why? That's how it's not well-grounded in logic and in fact. It also ignored contrary evidence. So what we have, for example, is the discussion about Dr. Steele and why he is gone. Dean Hanlon actually says on this record that he was let go because there were issues with the Fort Bragg billet. That is what's stated. So if it's the Fort Bragg billet, then it can't be the overall DOD cuts that Colonel Bell offers as to why he had to make the decision. And as we know, Dr. Bolanos said that Dr. Steele was just not a good fit. Well, if we're talking budget, we are not talking about whether someone is a fit at all. And
I had a question about that, Ms. Rucker. The notion that, you accurately reflect our law about conflicting or shifting explanations, potentially raising an inference of pretext, but I'm not sure that I see the conflict if an academic or if any employer is facing a budget cut and then they have to choose people to let go. It seems like it's a sort of consistent but subsidiary factor what the various potential layoffs bring. And so rather than being, impugning or somehow undermining the validity of the principal rationale, which is budget cuts, I'm not sure why we should infer from the additional evidence about, small but nonetheless noticed, issues or features of Dr. Steele's performance that would detract from the credibility of the principal reason.
So I'm not suggesting that it isn't. I'm just saying that at this particular point, when we get to this trial, there have been so many reasons offered. And I do understand that in academia, you do want to look at performance and other issues. But when you realize the fact that they actually said, meaning the academia, first of all, Bolanos tries to say I wasn't involved, but through impeachment, she clearly was involved. And then Dean Hanlon tries to say that he wasn't a good fit. Dr. Bolanos said he wasn't a good fit, which says that she's talking about something other than performance. And you have to look at the provost's letter, where that letter goes out and says, I think you made the right choice with Dr. Steele? Well, we're not talking a choice if it's really budget. And so I think those kinds of things kind of have to be looked at. And also, Dr. Bolanos in her EEO testimony said it was had nothing to do with budget. And so budget cuts. And so you can't overlook, when I say shifting explanations, it's just trying to hit a particular target. And I think in this particular instance, the fact that Colonel Bell said that I relied on the academia, the academic leadership, I think what happens here is we don't then get to give the weight that Judge Mehta gives to Colonel Bell's reasoning, because he said, I relied on what they told me. And Dean Hanlon admits that she told him, get rid of Dr. Steele. And so when you look at Dean Hanlon, what you have is Dr. Blau, who has nothing in this situation. I see my time has ended, and I'll be happy to come back and talk on my rebuttal time. Thank you, Your Honors.
Thank you, Ms. Rucker. Ms. Lyons, we'll hear from you now.
Thank you. Good morning. Jane Lyons on behalf of the Secretary of Defense, Lloyd Austin. May it please the court. The evidence this court had suggested at summary judgment could plausibly support finding age discrimination was entirely discredited by the district court sitting as the finder of fact at trial. The district court fully credited the explanations given for letting Dr. Steele go during his probationary year, as well as evidence of positive employment actions taken for older professors by the same actors. The findings of fact we submit preclude finding liability for age discrimination under any recognized standard, but as appellant has conceded this morning that the case has only been presented as a sort of single motive, to use the Title VII lingo, that's the single motive, then that is all that this court need to consider. And that is the standard that the district court applied in concluding that there was no age discrimination. I would like to make a couple points in response to my friend on the other side, whose arguments largely depend on disregarding the credibility determinations and reweighing the evidence in a cherry-picked kind of way. One of the things I would like to point out is that this court's review of this case at this point is limited to the trial record. And the credibility determinations by the district court are based not insignificantly on the demeanor of the witness. Additionally, the suggestion that other evidence of corroboration of the need for budget cuts and how those relate to the decision goes largely to credibility. The idea that there are shifting explanations here is incorrect. What the trial record shows is that budget cuts at the DoD caused there to be a directive to cut 3 faculty members. And so that's what sets a process in motion. The process was described extensively by Dr. Bell and his effort to get a waiver of the requirement for cutting any faculty members. But when that didn't come through, he had to choose from, they decided to choose only from among the probationary employees. 2 went out pretty quickly and pretty easily because their funding for their positions at the State Department had been cut. And so then Dr. Bell had to select from 4 remaining faculty members who to pick. And notably, although 2 younger professors than Dr. Steele were not cut, an older professor, a significantly older professor, Dr. Parker, was retained.
Can I ask
and
you,
as
Ms.
a matter
Lyons, on the district court, found that Dr. Steele's contract was terminated because of budget constraints and position cuts. But there were also hires going on at the same time. And I wonder if you can identify, I don't think the district court in its opinion really grapples with that evidence that the college was hiring new employees simultaneous with the process of selecting who to cut and terminating Dr. Steele. Can you walk us through how that doesn't undercut the claim of that budget cuts were a reason that they had to let go of Dr. Steele?
Yes, Your Honor. these events are not all ongoing simultaneously. And I think it's worth pointing out that Dr. Steele testified that he hesitated to take the job in the fall or late summer of 2010 because he acknowledged that there were growing recession concerns and indications of a lot of possible cutbacks at the Department of Defense. He testified those were obvious concerns for him. So that's the environment in which his relationship with the college begins. And the rumblings and the rumors about this need to cut 3 faculty members arises in the fall at the same time that the college is also being required to implement a new program entirely focused on Afghanistan and Pakistan. So there are competing dynamics there. And then Dr. Bell requests a waiver from the DOD, and he testified that he believed through the winter, and that Admiral Rondell, also above him, believed that that waiver would be granted. And then when it wasn't, they had to go through the process of picking 3 faculty members to eliminate, to comply with that directive. And then that decision was made and communicated to Dr. Steele on April 18th, 2011. And it was only later into the fall, late in the summer, early in the fall, when the National Defense University had some extra faculty positions that they were not using that were then reallocated to the college. And it is then that they go ahead and hire a couple of more professors.
I guess if you zero in just a little bit more specifically and just help us understand, there are some emails in the record where Dr. Steele mentions that in June, he was aware that people had already been or were being interviewed. And so it is back in the spring when Dr. Steele is being terminated that there's an ongoing process to identify new people to hire. And the conflict between, like, if they think they're going to have money, why aren't they thinking, well, instead of identifying new people, that might allow us to keep Dr. Steele. And I'm just not fully following the consistency that you see between planning to bring, I realize that they weren't brought on board until the fall, but planning to bring new people on board during a period when they're also finalizing the letting go of Dr. Steele. If you could just in a little bit more concrete way, walk us through the timeline of that and how that is consistent, that would be helpful.
There's a timeline, Your Honor, and you have that generally correct, and I don't dispute anything that you just said. But the important thing to recognize is that the timeline is not for a general hiring of new faculty. It is for a particular need that they have to hire experts in Afghanistan and Pakistan and counterterrorism. And the reason there are multiple things also going on with Dr. Steele, because his reaction to being terminated is part of what did not lead them to further consider him by the time they actually did the hiring. At the time they're doing some of the interviewing, there is very little evidence in the record about what else is in the applicant pool. And I think that would be a relevant fact to consider if we had it. Of course, we don't. So the reality is they are looking for particular specialties in this new program that they're going to have to stand up. And Dr. Steele is not an Afghanistan or Pakistan specialist, and he is not a counterterrorism specialist. So he's not a natural fit. And by the time they're actually doing the hiring, he has basically eliminated himself from consideration, his own actions.
This is not directly relevant, but just you may know the answer off the top of your head. If a institution like this that has short-term positions realizes, if we get rid of this one person who's more senior, we can hire 2 people who are more junior. Is that age discrimination or not? The fact that someone's more expensive and that you can actually get more employees, you may not know the answer.
It's an interesting.
It's not been argued here.
It's an interesting hypothetical because it assumes a correlation between age and experience and higher pay, which may or may not be true on any given record.
Right.
I think in particular here we have a record of Colonel Bell when he realizes that Dr. Parker is not paid as much, he goes ahead and gets him promotions.
Yeah.
So I think that yours hypothetical is interesting, but it's much
not
harder
this
to
case.
apply.
I don't want to eat up
record.
your time if you have other points you want to make.
I have one quick follow-up on your answer to Judge Pillard previously, which is you'd said that Dr. Steele, by the time that the three younger people came on board, he'd largely removed himself from consideration. So that at that point, that's not a budgetary reason. If I'm understanding correctly, because he's the reason stated for why he wasn't retained is for budgetary reasons. But then,
well, it's there's a lot of evidence in the record, Your Honor, if I may, just that the budgetary and the full-time equivalent positions and the budgetary issues are connected in ways that are quite complicated. So it was the requirement that they eliminate the 3 full-time faculty positions in the spring that led to Dr. Steele being let go. And if I understand your question correctly, maybe I don't, but perhaps you could ask me again.
right. Well, at the end of the response to Judge Pillard, you'd said that by the time the 3, I guess that would be Gresh, Pacavola, and Miser, by the time they came on board, Dr. Steele had largely removed himself from consideration. I think I heard you say that, but correct me.
Yes, Your Honor, that's correct.
And so if he'd removed himself from consideration, then the reason that he wouldn't have been retained, that's not a budgetary, you don't remove yourself from consideration for budgetary reasons. That's something else.
Well, at that point, he does not have an ongoing relationship with the college, and there's no evidence in the record that he applied for any of the positions for which those individuals, 2 of them were selected as regular faculty and 1 was a contractor.
Right. So if it's that he didn't apply, then do you mean he removed himself from consideration by not even applying? I thought you were talking about something else.
I mean in 2 ways. He did not, his reaction to being let go and his conduct is what led the college to sever the relationship prematurely. And as an additional reason, he had not applied for consideration in these Afghanistan and Pakistan specific programs.
Okay. All right, let me make sure my colleagues don't have additional questions for you, Ms. Lyons.
No.
Thank you. Ms. Rucker, we'll give you back 2 minutes for rebuttal.
Thank you, Your Honor. At this particular point, I wanted to address something that the court pointed out and sort of honed in on, which is very critical to this case. At this particular juncture, when you're looking at in June, well before, right in the mix of telling Dr. Steele in May that we have to let you go due to budgetary cuts. Now we have in June an announcement to the faculty that we have these new people coming on. That is critical. It is inconsistent, and that is exactly what we mean when we say that this decision is not well grounded in logic or fact. It has no basis to be supported and is subject to reversal for clear error. And when we also consider what the court asked in terms of the idea that well, let me just deal with the answer that was given, is that there were hiring restrictions and that Dr. Steele somehow or another had taken himself out of contention. The lower court actually dealt with this towards the end of the trial, where it said, why didn't someone just tell him? So what is being referenced here about him taking himself out of contention is repeatedly trying to understand, why is this happening to me? It is not logical. It makes no sense that someone who was heavily recruited, such as Dr. Steele was, would suddenly not be a candidate. And it also is, this placeholder argument that we've been making is also present when you look at the fact that Dr. Steele rejected a Fort Bragg billet. Ultimately, he was obviously placed in that same one because they needed to hold that place, but he was never going to stay because they were looking in June and then in fact brought people on who were younger to do and to keep people who taught the same courses he was teaching. And it is also very critical to point out that in Dr. Steele's talking about Mr. Uko and others, no one controverted the fact that he himself said that he was also qualified to do this work. It is uncontroverted. Even though these people may have had the ability to do this, it still doesn't answer what this court asked at the beginning of Steele 1, which is, Even if you had to make cuts, why Dr. Steele? I believe that that's still been not answered. We ask for this decision to be reversed and that Dr. Steele receives all that he is entitled to under the law. And thank you, Your Honors, for your time this morning.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you again, Your Honors.
Case number 15-1054 et al. Center for Biological Diversity et al. Petitioners versus Environmental Protection Agency. Mr. Evans for the petitioners, Mr. Jacoby for the respondent, Ms. Berman for the interveners.
Morning, counsel. Mr. Evans, please proceed when you're ready.
Good morning, Your Honors. May it please the court, Jonathan Evans for petitioners. I'd like to reserve 3 minutes for rebuttal. I'll be stopping at the 3-minute mark unless Your Honors have questions. I'll first address today why this court should enter the proposed order providing deadlines for the Environmental Protection Agency to comply with the Endangered Species Act. This case presents a unique opportunity where all of the parties are aligned in asking the court to effectuate a carefully balanced approach to resolve this case. Should the court decline to enter that order, setting deadlines, I'll focus on why vacating the 4 registrations that still remain at issue in this case is the appropriate outcome here. At the outset, petitioners urge the court to follow the clear path forward set by all the parties to this case and enter an order setting deadlines for EPA's compliance with the Endangered Species Act for the remaining 4 pesticides at issue in these consolidated cases and effectuate the settlement agreement. The settlement agreement has already borne fruit through label changes to the pesticide for cuprocyanide, reducing the risk to endangered species like salmonids, and also keeping the product available but under safer uses. Entering the proposed order would also trigger enhanced environmental protections in the settlement agreement, such as the establishment of an interactive, geographically based website detailing locations for ESA protected species that could be affected by the 4 pesticides and steps to mitigate harms in those specific locations. It also establishes a meet and confer process after the draft biological evaluations are completed by the Environmental Protection Agency, the first step in their compliance with the Endangered Species Act here, to allow the parties to negotiate potential future mitigations to reduce harm to Endangered Species Act listed species, like happened with cuprocyanide, to streamline the future consultation process and reduce harm and allow the pesticides to remain on the market. It would also provide important regulatory certainty to the regulated community and to EPA. Without a court order, future benefits from the settlement agreement become null and void.
Can I just ask you one technical question? So for the pesticide that's already been dealt with, it's cuprocyanide, I think.
Correct.
I take it that is everybody on board with dismissing that petition as moot?
Petitioners agree that EPA met its ESA obligations by changing the labels to reduce the harms to endangered species and coming forward with that no effect determination that says there's no effect on endangered species. Petitioners are not disputing that determination.
And is the consequence of that then that the petition associated with that one would be dismissed as moot?
Dismissed, Your Honor, whether the decision was made as a result of the party's settlement agreement or mootness is something that we haven't negotiated with the other side, but we do agree that that's no longer an issue here.
Okay.
Mr. Evans, can you explain for me, what are the advantages that you believe the parties gain by the court retaining jurisdiction over this?
That's a good question, Your Honor. As the briefing shows, unfortunately, the Environmental Protection Agency has had substantial challenges in complying with the Endangered Species Act. And we've seen consistently when EPA has complied with the Endangered Species Act after it has been resulted in litigation, it's only been when the court has retained jurisdiction and when it has proposed deadlines for EPA to act. Unfortunately, when the court has remanded without vacatur and not retained jurisdiction of EPA's actions, such as the case of the cyanotropyl pesticide, which is Center for Biological Diversity versus EPA 861 F3D 174, the petitioners have been forced to return to this court to seek redress for EPA's continued violations of the law. EPA's failure to comply with both the congressional mandate of the ESA and this court's remand order require petitioners to once again return to this court last year, over 4.5 years after the court's remand order and 8 years after the initial registration, to enforce the rule of law by filing a petition for writ of mandamus in Re Center for Biological Diversity, case number 21-1270 in this circuit. Forcing the petitioners to return to the court strains judicial resources of a clear remand order that the agency should have complied with. It also provides an improper burden for petitioners to achieve it.
How does the consent order make it easier for you to get relief if the EPA continues to miss deadlines?
But by the court retaining jurisdiction, we simply, the consent order does two things. It provides deadlines. Well, I guess two things. Provides deadlines, it retains jurisdiction, and it allows the settlement agreement to be effectuated. By the court retaining jurisdiction, the agency has been demonstrated that it's incentivized to act. When the court doesn't retain jurisdiction and doesn't provide deadlines, we simply see each EPA's priorities changing. They don't really address the court's clear remand order. So that's why we think it's crucial that the court retain jurisdiction and order deadlines.
Is that really a problem with the remand without vacator remedy itself?
Well, absolutely. I mean, the Science-Chernobyl decision is a concrete example of how EPA's kind of unfortunately flaunted the court's order here and the congressional mandate. So we have to return and then come back and seek a petition for writ. The whole time, EPA's violations of the law are ongoing, harm to endangered species are occurring, and we just don't think that that's the appropriate judicial outcome. And also looking at what the Endangered Species Act requires, which is prioritizing the impacts to endangered species, not allowing ongoing harm to endangered species to occur. We do think that making sure that the agency does comply with this court's remand is important. And unfortunately, the record here and the EPA's history demonstrates that it has had shifting priorities in complying with the Endangered Species Act.
Mr. Evans, what happens with the merits claim and the maximally available relief for your clients under three scenarios? One, I guess we could rule against you. The other, we rule in your favor and remand without vacature. And so really, it's just that, we remand without vacature as we did in CBD 2017, or we hold an abeyance. And in light of the settlement, in the latter, how would you, or in either situation, I'm sorry, how would you prompt the court to, for example, decide to vacate these registrations? That's sort of in the background, that's your cudgel, right? And I guess I'm wondering the fate of that under the different scenarios.
If I could just clarify the question, Judge Pillard, you asked the two, thank you for indulging me. The two questions were, well, two paths were, if the court remands without vacator, what do we do? If the court maintains the case in abeyance while EPA complies, what do we do if EPA doesn't comply?
Yeah, is there, it seems to me that the availability or the prospect or the risk from EPA's and interveners' perspective that a court might hold that these registrations are invalid is somewhere in the mix. It's just not entirely clear to me where it is in the mix under the alternative scenarios. Does that make sense? I know that's.
I think so. If EPA fails to comply with the consent orders, the proposed orders and the consent decree, if that settlement agreement doesn't become effectuated, this is under the scenario 2, we go back to the court, either asking for EPA's compliance or asking for the court to vacate the pesticides because EPA has continued to demonstrate it won't comply with this court's deadlines. We don't think that is likely. We certainly hope that it is likely. In EPA's history, it hasn't demonstrated that's the case. Under the remand without vacator scenario, we do what we did in Science-Chernobyl and come back and have to ask the court to issue an order deadline, which we already have here. So, in other words, we can really achieve the outcome that is most beneficial for the parties, most efficient for the court, and enhances environmental protections here without having to string this case along, which has already been protracted for many years through a petition for writ of mandamus, as we had to do in the Science-Chernobyl case.
Okay, it could be remanded without vacator, but with deadlines.
It could, Your Honor. The settlement agreement does provide for some requires deadlines, but does require the court maintaining jurisdiction. We do feel that maintaining jurisdiction is essential for making sure that the agency does comply with the law. Because
I thought your position in your briefing was that you were not, that the settlement, you were not on board with that, as that's not part of the settlement as you negotiated it.
It is not part of the settlement as we negotiated. If the court does remand without vacater and deadlines, we'd have to evaluate, how we can potentially salvage a settlement agreement if it's possible, because we do think it still has merits. But we do think it's important in order to streamline the potential beneficial outcome for all parties, enhance environmental protection, is to move forward with deadlines and jurisdiction, because that's what has demonstrated that EPA will act to comply with the law in the past.
Well, why wouldn't it work to I'm not suggesting that we necessarily have to do that, but I'm not quite understanding if we remand without vacater, but have deadlines, which are the deadlines that have been negotiated now. And that sort of thing has been done before, where the court has remanded without vacater and then had a deadline in effect pursuant to which a lapse of the deadline would mean that the relevant instrument would be treated as vacated. So the registration would get vacated if the agency hasn't taken action in concert with our decision by the deadline. That doesn't work because
that doesn't work, I guess, because it really places an unfair burden on petitioners to come back with a petition for writ to achieve the extraordinary remedy of a writ of mandamus, and then we have to argue the track factors. And if the court issues a deadline, it does, it does say that EPA's, that is a reasonable timeframe within which to react. But we do just think that it really burdens the court and the parties with unnecessary action in this case, when it can simply retain jurisdiction for a limited time period. And this court has done something similar in Re Idaho Conservation League. 811 F3D 502 provides clear precedent for ordering deadlines for agency action, retaining jurisdiction to enforce those deadlines for over 8 years, longer than what we have here, based on a joint motion from the party. So,
Mr. Evans, that's the only case, right, in which this court has done that. So it is fairly extraordinary. There might be some precedent for it, but it's a fairly extraordinary action for this court to kind of just oversee the implementation of deadlines by a federal agency.
Well, we think that actually all the parties provided in the May 2021 response to the motions panel show cause order. There are numerous cases where the DC Circuit has ordered deadlines and retained jurisdiction. I think one that is particularly appropriate here is Public Citizen Health Research Group versus Octor. After a delay of 3 years, ordering the agency to issue a notice of proposed rulemaking within 30 days and a final rulemaking on a priority expedited basis as promptly as possible. Indeed, and I think that there again, the parties cite in their May 2021 response to show cause order as numerous circumstances where the court has issued deadlines and retained jurisdiction. I will, Judge Rowell, I agree with you that normally they're much shorter, on a much shorter time frame. And we wish they were a shorter time frame here, but the settlement agreement and consent order was a compromise by the parties and recognized the exigencies that the EPA represented in terms of complying with ESA. So we entered into a compromise to find the deadlines that we thought would achieve our beneficial outcome.
Where does our
Mr. Evans, the
authority,
relief? Oh, go ahead.
I was just going to say, where does our authority come from to take that action, even if there are cases that do that? Do we have a statutory authority to do that?
Well, the statutory authority, the Endangered Species Act, provides for clear authority for the EPA making that decision making within a bounded time frame. And we're not asking the court to engage in any type of administrative, type of effort. We're just simply saying the court can provide a deadline like Congress did. The Congress said, EPA, you need to consult before the registration, before the agency action occurs. We're asking the court to set a deadline. EPA, you need to act. And that's the end of what we're asking the court to do in terms of deadlines. And
the statute says we can affirm or set aside the orders complained of in whole or in part.
Correct.
So it cannot be either affirming or setting aside.
I guess two things to get specifically to your question. Cobell versus Norton, that states that the court maintains equitable discretion as well as legal discretion in terms of crafting remedies. And we also think that affirming and setting aside in whole or in part, the court can, in part is allowing the decision to continue to remain on the books while the agency complies with the law. And we don't think that that is inconsistent with the statute.
So you're just saying it's a slow motion affirm. It's like we're affirming, but when certain conditions are met. So we would
Correct.
make our action on the case ultimately before it's dismissed would be to affirm if all goes well.
If the EPA complies with the Endangered Species Act, which it is stated it will on the order, it would.
That's the point of the consent order. Why? I mean, I know your merits briefing asked for vacatur. You know, the EPA has acknowledged obvious failure to comply. What's the scenario there? If Judge Rao's, the implication of Judge Rao's question is correct, that we don't actually have the option to enter the consent order and retain jurisdiction, vacate these certificates and decide the case on that ground.
Well, the settlement agreement doesn't, or the proposed order doesn't do anything to contravene that the presumptive remedy in a circumstance like this is vacatur. And as the court recently affirmed last year in Standing Rock Sioux Tribe versus U.S. Army Corps of Engineers and Farm Worker Association of Florida versus EPA, the presumptive and appropriate remedy for unlawful agency action is vacatur. And we think that given the history of EPA's failure to comply with the Endangered Species Act, that vacatur is the only other circumstance that would incentivize EPA to act, because when this court remanded without vacatur, EPA has still failed to comply with this court's order 4.5 years after it issued it. And I see my time is up. I'm happy to answer any more questions or save my remaining time for rebuttal.
I think we'll give you your time for rebuttal. We'll hear from the government now. Thank you, Mr. Evans. Mr. Jacoby.
Good morning, Your Honors. May it please the court. I'm Patrick Jacoby from the Department of Justice on behalf of EPA. Your Honors, EPA recognizes the seriousness of not meeting its ESA obligations when registering products under FFRA. Here, EPA has done its level best to identify dates for effects determination, to commit to those dates, and to resolve the 4 non-moot petitions. EPA has even, as Mr. Evans noted, completed its ESA obligations for one of the petitions. The court is not inclined to enter the proposed order to resolve the 4 non-moot petitions. Then EPA requests that the registrations be remanded to EPA without vacatur for 2 main reasons. First, EPA's commitment to deadlines for effects determinations counsels against vacatur. Second, the balance of the equities also counsels against vacatur for reasons similar to those identified and discussed by this court in the 2017 decision regarding the active ingredient cyanotraniliprole. Turning to the first point, EPA has negotiated, as you've discussed with Mr. Evans, a proposed order and settlement agreement in good faith, has provided a sworn declaration of EPA's intent to meet the deadlines set out in that agreement. So this is not a case where EPA has refused to commit to deadlines at all. EPA has met the deadlines for ESA Section 7 compliance in the proposed order for cuprous iodide during the pendency of these petitions and the pendency of the proposed order. EPA also more broadly has made and continues to make meaningful steps towards making its ESA obligation or meeting its ESA obligations on FFRA registrations. These range from some of the programmatic efforts we discussed in our brief at pages 5 through 7 to the more recent announcement that EPA will include ESA analysis for new active ingredients prior to registration going forward. These are important steps, and EPA is acting in good faith to address this problem. So overall,
I wonder, I mean, I understand why the government does not want vacatur here, and I understand the difficulty of complying with these requirements and the time it takes and the resources and all of those things. But is the government concerned at all about the precedent that that if we entered this consent order, the precedent that would set? I mean, we see cases all the time in the circuit about agencies failing to meet their deadlines. And I don't know, I mean, this long-term consent order where we oversee how the EPA implements its various policy priorities, how it, deals with limited resources, and all the different reasons why there are delays in agency action. I mean, does the government want this court to superintend those types of delays in agencies? I mean, how do we distinguish this circumstance from others? And I'm just interested in the government's institutional position about why the executive branch would want judicial oversight over this type of highly political and executive function of figuring out how to do interagency review with competing priorities.
Your Honor, I'll try to answer the question without divulging any privileged information on behalf of the government. It is a concern, and one that we take seriously. This section, the environmental defense section, appears before this court quite frequently in situations regarding petitions for review. So it is something we've considered carefully. I think, Your Honor, our preference and our initial volley, if I recall correctly, was a stay during the pendency of these deadlines, which is more in line with what we think this court has done in other situations. For example, I believe there's a stay in a case called DBA versus Nuclear Regulatory Commission at 492 F3rd 421. That's a 2007 case. It's an open-ended, years-long abeyance that's been going on for more than 10 years, where there's an attempt to comply. Is
that the waste case?
I believe it is, Your Honor. It's
the nuclear waste.
It's been a while since I looked at it, but yes, I believe that's correct. That I think we would have said was the correct way to go. However, because of the risk of vacature here and the fact that we don't have a merits defense, we had to weigh the potential risk of vacature, the potential litigation risks, and we worked extensively with the petitioners to come up with what we thought was an acceptable procedure, which was not, a CD, for example, but a consent motion asking the court to enter a proposed order and retain jurisdiction under the proposed order. I think it's pretty similar to a stay. I think what it provides that a stay doesn't is basically some of the benefits Mr. Evans identified regarding the website that they have set up with the registrants, some of the interim procedural pieces that allow them to meet and confer with the agency, that type of thing.
I'm confused by that because those things are all required. I mean, they're not specifically chapter and verse, but it's required by the statute that you meet and confer. It's required by the statute that you organize, not you, but that your client organize agency functions in a way that better enables it to meet the deadline. So the website and the, would be efforts that you don't need any court supervision or any consent order to have authority to take those steps. So I understand that they're productive and that the lawsuit has occasioned engagement among the parties now before the court, but the authority for all of that is in the statute, no?
Your Honor, I don't disagree. I mean, I think EPA could work with the petitioners to take those steps. I'm not sure that as I sit here right now, I'm not sure that every single thing in the proposed order is necessarily required on behalf of EPA, but certainly EPA could undertake all those steps. And
right, as its choice of how to be better positioned to expeditiously meet its obligations. Let me ask you, you had laid out two reasons why you were remanding without vacature. And I think we interrupted you after you got through your first. First was that the EPA's commitment to deadlines sort of shows its good faith and bona fides. And the second was, you said, the balance of the equities that's similar to the position in the 2017 case. And I wanted to probe you more on the second. I mean, doesn't Standing Rock apply here? If you skipped a required procedural step, we can't remand without vacature unless you've established that you were justified in skipping that step. And I don't see an argument to that effect. How could we, in this case, remand without vacature given Standing Rock?
Your Honor, I think that is a tricky question. I'll grant you that. So let me begin by saying I don't read Standing Rock to materially revise the court's analysis in the Cyan-Trinell decision, which I think is the most applicable here, given the statute, the facts, and the analysis and the record. So, I think that's the easiest, shortest answer. I think the harder answer is And I also think Standing Rock is distinguishable on the facts and the fact that it's a NEPA case, which I won't go into unless the court wants me to. But I think the more important question is, I'm not sure I know how far this court intends to extend Standing Rock. Is it the case that if there's a minor notice error or required notice in any agency petition that will require vacature? That would seem to take things too far, I think, and would maybe read Standing Rock more broadly than it's set out to be. So I think that about sums up how I see things. I think the easiest answer is I don't think cyanotropil is barred from application here after Standing Rock.
This situation is different in terms of what, in a number of ways.
This situation is different from cyanotropil. Is that question?
Yeah.
Your Honor, the main difference is that the court used the reduced risk designation as a shorthand in cyanotropil. Reduced risk is not something that's done for every applied for use. It's actually usually always done at the request of registrants who are seeking expedited review. So it's just a shorthand.
But we don't have that with respect to each of these four remaining chemicals, do we?
No, you have it for many uses, but the larger point is just because there wasn't a reduced risk analysis doesn't mean that the products aren't actually less risky than the alternatives. And if you look at the record and what we've presented in our briefs, I'm happy to go through it. There is quite a bit of analysis of not only the environmental benefits through a reduction in risk compared to older alternatives, reduction in the use of those older, riskier alternatives, and obviously food supply and benefits to growers that we think are very important, many of which translate into environmental benefits, reduction in tillage, reduction in application, improved water quality. I see that I'm almost out of time. So unless there are further questions, I will close and say we request that the court dismiss the Cooper's iodide petition as moot and remand the four remaining petitions to EPA without vacature. If the court chooses to set deadlines, we would, of course, request that those be the ones we agreed to in the proposed order. Thank you.
Thank you, Mr. Jacoby. We'll hear from Intervenors Council now, Ms. Berman.
Thank you, Your Honors. Good morning. We join EPA and petitioners in asking this court to enter the consent order. The settlement was the product of years of negotiation, and it does include meaningful commitments from my clients as well as EPA. If the court does not enter the consent order, many of the benefits of the settlement go away, including intervenors' provision of additional information on a website to educate growers on the location of endangered species and specific label requirements of these products that protect them. And Your Honors, I do not think that is.
Can I ask you at the outset, so you've raised a standing objection?
Yes, Your Honor.
I take it that if we were to agree with you on the standing objection, we couldn't enter the consent order.
Your Honor, I don't think the court needs to reach standing if it enters the consent order. This court has many times held cases in abeyance, which is what the consent order would do, waiting for EPA to take action without ever diving into the issue of whether there is a standing issue in that case before that issue is ever raised in brief. So if the court is entering,
how is it different from Idaho in that respect? Because is there a material difference? Because in Idaho, the court went through standing analysis first.
Sure. So, Your Honor, in that case, it did. I don't think it's necessary. I would point the court to the American Chemistry Council versus EPA case from 2016, where the court held the case in abeyance while waiting for EPA to act to fulfill a settlement. I don't think there was any standing analysis there. Generally, if a case is being held in abeyance so that EPA can take an action that may moot the case, that happens before there is any briefing on the standing issue. Now, if enforcement
of the deadline, so wouldn't we have to? If the whole idea behind our keeping it is that there's deadlines and then we retain jurisdiction so that those deadlines can be enforced, it doesn't matter if they're standing? Still doesn't matter?
Your Honor, so long as the court holds the case in abeyance, I don't think so. Now, if the court doesn't, if the court were to instead look at remanding with or without vacature, we do think it should reach the standing issue first. And I would like to mostly rest on my briefs in regard to that issue. Our key point was that it's petitioner's burden, as this court emphasized last year in the Food and Water Watch case, to put forth evidence showing that there will be redressability, that third parties will act in a specific way so as to alleviate the harm claimed, and we don't think they've done that. But Your Honors, what I would really like to take my time to do today is to urge the court that in no event should it vacate these registration decisions. Not only are they the result of decades of work and over 1 billion in collective investment by my clients here, the point of these individual active ingredients is that they are both more effective and less environmentally impactful than the alternatives that they replace. And EPA
another difficulty that we have in this record compared with the record in the 2017 CBD case, where we don't have assertions by EPA that each of these pesticides is actually less risky. I think we have something close for fluperidifferone, but not for the others. For haloxyphene-methyl, they only say that it may be better than older pesticides. So I just don't see how we can take your word for that on this record.
Your Honor, I would respectfully disagree, and I'd like to point you to specific places in the record that I think get us there for the other active ingredients. As DOJ counsel pointed out, the reduced risk label is a helpful shorthand, but it's not determinative on this issue. So for haloxyphene-methyl, for example, at page 307 of the joint appendix, EPA explains that it has much lower use rates than the alternatives that it would displace, and it uses the word displace. EPA also explains, and you can see this ranging from pages 299 to 307, that it is less persistent in the environment and it is practically non-toxic to animals as well as humans. For bicyclopyrone, for example, I would point the court to page 122 of the record, where EPA explains that because this active ingredient is much more effective.
What page was that?
122, Joint Appendix 122. EPA notes that because it's more effective in smaller quantities, again, a lower use rate, one pre-emergent application can avoid multiple post-emergence applications of pesticide, resulting in a decrease in specific older, riskier pesticides, such as atrazine is the one noted there, as well as several others by EPA. So yes, while
petitioners claim that EPA didn't consider, indirect effects, joint effects of bicyclopyrone, with multiple other active ingredients. And, so we have competing characterizations on the record. We don't have a determination by EPA. I don't think we can kind of de novo just credit evidence. That's for EPA, and it hasn't done that.
Your Honor, respectfully, I think EPA has done that. On synergism, the issue you note, in every one of these registration decisions, EPA addresses the speculation that there might be synergistic effects from mixing with other compounds. For example, at Joint Appendix page 300, EPA explains synergism is rare. It's only been found in limited circumstances. There are no synergistic claims or suggestion of synergistic effects here. So frankly, Your Honors, EPA did address these issues very thoroughly in the record, in the benefits documents, in the risk assessment, in the registration decision. And for each one of these active ingredients, it explained that they are improvements, that they are better than the older pesticides that they would replace. And so vacatur would have an impact here that's at odds with the Endangered Species Act, just as was the case back in 2017 in regards to CTP. And so in conclusion, Your Honors, because I see my time is up, my clients, they share many of petitioners' values. These are chemistries that were designed to be both more effective and more targeted, lower risk to the environment, so that food production is sustainable long-term. And so we would ask the court first to enter the consent order negotiated by the parties which protects those values, but if not, above all, not to vacate these registrations. Thank you.
Thank you, Ms. Berman. Mr. Evans, we'll give you back the 3 minutes that you'd asked for rebuttal.
Thank you, Your Honors. I'll just briefly touch on some of the questions raised by the court and some of the issues raised by the other parties. First, Judge Rao, I apologize, I didn't have the cites on hand, but your question about the court's authority regarding the order to enter the deadlines, the petitioners and the interveners and EPA all briefed that in the response to show cause. That's at document 189-7864, pages 8 to 10 for petitioners. Interveners, document 189-7868, pages 13 and 14, and EPA 189-7888 at pages 7 and 8. Again, citing to Cobell versus Norton, the courts are presumed to possess the full range of remedial powers, legal as well as equitable, unless Congress is expressly restricted otherwise. Judge Pillard, you asked about the settlement agreement regarding the website. Importantly, that settlement agreement is between the between the petitioners and the respondents, and EPA has chosen not to waive sovereign immunity, which is why we need the consent orders or the orders for deadlines from EPA in order to effectuate the settlement agreement. The court asked about this, and the EPA cited to the Cyanotronilopol case. And in addition to the reduced risk issue, I really want to emphasize that the substitution theory is quite the red herring. There is no evidence that these pesticides would be substituted for more environmentally beneficial substances. Indeed, the registrations of some of these pesticide products are literally combined with more hazardous older pesticides such as atrazine and 2,4-D. That's at Joint Appendix 150, 240, 345, and their labels emphasize that these pesticides should be combined in tank mixtures with older pesticides. That's at Joint Appendix 83, 85, 166, 246, and 354. And the evidence before this court is that new pesticide approvals is actually correlated with increased pesticide use. For the past 14 plus years where there's data, new pesticide approvals is actually correlated with increased pesticide use for corn and soybeans, some of the biggest crops in the United States. That's at petitioners' reply declarations 175 to 181. So the substitution theory is quite problematic. And as Judge Pillard, you alluded to, these pesticides work additively. So when any organism is affected by multiple chemicals from multiple sources, they provide additional stresses and toxins. So they will stress endangered wildlife such as the whooping crane and sandwalk and kit fox, not reducing harm, but adding more pesticides. And the issue of standing, the cuprous iodide is a clear example that petitioners' injuries are redressable. Their EPA took action, complying with the Endangered Species Act, eliminated the harms that were most problematic for imperiled and endangered salmon and other fish. Petitioners' injuries were addressed, and that claim is no longer allowed. I'll rest on that. I encourage the court to enter the orders and effectuate the settlement agreement. Thank you very much.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 21-5057, PayPal Inc. versus Consumer Financial Protection Bureau, and Rohit Chopra in his official capacity as Director, Consumer Financial Protection Bureau. Mr. Deal for the appellants, Mr. Shanmugam for the appellate.
Good morning, counsel. Mr. Deal, please proceed when you're ready.
Good morning, Your Honor. May it please the court, Christopher Deal for the Consumer Financial Protection Bureau. The Bureau's prepaid rule requires that consumers get a short, easy to read disclosure before they sign up for a prepaid account. This appeal is about the Bureau's statutory authority to issue the rule. The district court held that the Bureau lacked that authority on the theory that the Bureau's rule prescribes mandatory disclosure clauses. The district court was wrong. The reason is straightforward. The rule doesn't prescribe any mandatory disclosure clauses. Instead, as relevant here, the Bureau's rule has three basic elements. The rule mandates the content of the short form disclosures, it regulates the format of those disclosures, and it provides optional model language for use in the disclosures. First, the content requirements. The content requirements specify what information providers need to disclose in the short form. Many of these content requirements are about fees. For instance, providers need to tell consumers what their ATM withdrawal fees are and how much the institution charges consumers for reloading cash into their accounts. Providers.
Can I just, I'm sorry to take you off the sequence that you had in mind, but can we just skip ahead to wording just for 1 second and then we can please circle back to content. So I take it that the premise of your argument is that you don't contest the idea that because of the statutory language to the effect that the Bureau shall issue model clauses for optional use, that the Bureau doesn't have the authority to issue mandatory clauses. At least that's the premise on which this case is being litigated by both sides. And if that's true, then I guess my question is this: if the Bureau gives two options for wording and says you have to do either wording A or either wording or wording B, then would that be consistent with the premise that there can't be mandatory clauses, even if we buy your argument that clauses is limited to wording, putting to one side content and formatting?
Your Honor, in that case where obviously that's not what happened here, but where the agency said you can use this clause or that clause, I think that would be a much closer question. I think the court could conclude in that circumstance that the Bureau had prescribed the particular clauses that could be used. But here we don't have that. Here we have, you may use a particular optional clause, or you can use any other clause, any other wording that's substantially similar.
Right, and so then I guess the question becomes, if you think it's a difficult case with two options, then the question becomes, how many options are there if it's substantially similar? I mean, I think you know where this is going. And so what is the range of options for substantially similar? And this is going to get complicated, and I apologize for complicating the question, but it seems to me self-evident that the range of options is going to depend on the narrowness of the content requirement to begin with. And so even if we buy your argument that content is just off to one side and content doesn't have to do with model clauses, what model clauses has to do with is wording, then the number of wording options is going to be predicated to a large extent, to a considerable extent, it seems to me, on the narrowness of the content requirement to begin with. And here, some of the content requirements seem reasonably specific, and that may well be perfectly fine, given the authority of the Bureau to prescribe content requirements. But then it raises the question, well, then how many options are there really for wording, even if there's an allowance for substantially similar wording?
Sure, Your Honor. So I think that it's important to not lose track here of the fact that we have is a congressional provision that requires optional model clauses. There isn't a standalone prohibition on cutting out flexibility for institutions. So I think the interpretation that's advanced by PayPal really creates the problem that it would suggest that whether or not the Bureau can require an institution to disclose a particular fee, how much they charge for ATM withdrawals, how much it costs to add money to their account, depends on how many different ways there are to say that in the English language. And I don't think there's any textual basis for that kind of a conclusion. I mean, you can look, for instance, at the content requirements that are included in the statute itself in 1693C. One of those requirements is that the institution has to provide the telephone number and address of, who the consumer should talk to if they have they think there's an unauthorized electronic fund transfer. By providing that, obviously the institution has to provide the correct phone number, the correct address. There aren't, a million different ways to say that. So I don't think that there's any necessary inconsistency here.
Then I guess the question becomes then, and I'm not saying the agency lacks the authority to do it, but I'm just wondering programmatically why do it? Because if the content requirement is pretty specific, and we assume for purposes of this argument that the content requirement can be imposed, then why cabin it to substantially similar language? Because there's always the authority on the part of the agency, I assume, to say, well, you're just not complying with the content requirement if you use wording that doesn't comply with the statutory directive that it has to be readily understandable. You're just deviating too far from the content requirement. What does the substantially similar proviso add that matters to the agency?
What it adds is it ensures that consumers can readily compare one disclosure form to another. Mm-hmm. And I think I think you're exactly right to note the connection between the substantial similarity requirement and the readily understandable requirement. I think they're getting at the same idea. This provides some additional, sort of meat on the bones, some additional way that the agency implemented that statutory requirement to ensure that when consumers are looking at the form for one prepaid account and they're comparing it against another one, that they can kind of compare apples to apples as opposed to having to wonder, oh, is this really the same fee or is it a different fee? While at the same time that the institutions retain the ultimate ability to pick an appropriate disclosure, within those sort of content and language bounds.
But Mr. Deal, I mean, does the Bureau, can the Bureau, I think you agree that you can't issue mandatory model clauses. And so my question, perhaps following up on some of Judge Srinivasan's questions, is by adding substantially similar, can you just simply avoid that prohibition? Right, because I mean, the way that the rule is, in multiple provisions reads is there is a content requirement and you satisfy the content requirement by using a specified term or clause or something substantially similar. And I'm wondering really if just by tacking on substantially similar, you can avoid the restriction on mandatory model clauses.
So two things, Your Honor. One, just to be clear, we're not disputing that we lack the authority with respect to mandatory clauses for purposes of this case, because we don't think we did them and we want to simplify things. But I don't think that the substantial, as I was trying to explain before, I don't think that the substantially similar requirement is intended to be an end run. It's not trying to force institutions to say the magic words. It's rather intended to provide, consistent with the statute, a surefire way for institutions to comply, so they can know, if I do this, I'll definitely be complying, but also give them flexibility to pick other things.
Why isn't that sort of on the EFTs, right? So either they can use the clause that's been provided in the rule, or they take the risk of drafting their own language and complying with the content requirements. And then, the Bureau can take action on the back end. I mean, this in some ways seems to be trying to just ensure, fewer enforcement actions or something like that. Like, I'm not sure what you really get. I mean, there are already so many incentives for EFTs to just use the language that the Bureau has provided. So if for some reason they want to comply by using some language that maybe you think is not substantially similar, I guess I'm not sure where the authority comes from to kind of capture that, to capture those, that type of wording, since you're not allowed to, or at least arguably the statute doesn't give you the authority to do a mandatory model clause.
Well, I think a couple of things, Your Honor. One is that it's important to think about the overall structure of the Bureau's authority here. The Bureau has broad affirmative authority to issue rules to implement EFTA, and it's very clear that the Bureau has authority to issue rules with respect to disclosure requirements. Congress repeated that there. And then we have an optional model clause provision, which does not say doesn't say the Bureau can't do anything. We're sort of, granting the premise for purposes of this case that the Bureau can't do something that's inconsistent with that provision, that conflicts with that provision. And so I don't think that saying here's an optional model clause, use it, or use something that's substantially similar is in any way inconsistent with the obligation to issue optional model clauses. It doesn't, it perhaps narrows somewhat the range of options, but it does so in a way that's entirely consistent with the statutory scheme related to readily understandable language.
Would it not allow for side-by-side comparisons, which was part of your response, I think, to both of us on what's the advantage to cabining to substantially similar? And I take the point that the Bureau is interested in putting into effect a framework that allows for side-by-side comparisons on the part of consumers who, under the statute, have the benefit of wanting to be able to do it through readily understandable language so they can understand what the various conditions are. If the Bureau prescribed the order of the various content requirements, but then without the proviso of substantially similar language, would that still facilitate a side-by-side comparison? Because you could still see the first one and the first one, the third one and the third one. Do you understand what I'm asking?
Yes, Your Honor. I think that the Bureau's conclusion was that each of these elements help serve the same goal, right? They add together to make it easier for consumers to understand, to know what's going on. And I would note that the structure of the disclosure is that there are static fees, fees that everyone needs to disclose. Those are the most common, most important fees. And then there are also some additional fees that are institution specific. So there's, already going to be some amount of disparity. So I don't think that I don't think that the mere fact that there are some different language is going to necessarily cause, a huge problem. But
Right.
What the Bureau was after here was to try to make it as easy as possible for consumers to be able to do that comparison. And each of the elements of the rule together adds to that effect, ensures that that goal can be met.
Mr. Deal, can I ask you a question about remedy? I mean, if we were to agree that the prepaid rule imposes these mandatory model clauses, and Judge Leon's remedy was to say that the short form disclosure exceeds the bounds of the Bureau's statutory authority to the extent it requires providers to use the Bureau's disclosure forms. So I note in your reply brief, you said that we should sever a provision. I mean, what would the remedy look like? I mean, do we have to, I assume obviously you would not want us to vacate the rule, but how would to the extent that remedy, what would that even look like when it was sent back to the Bureau?
Yes, Your Honor. So a couple of points on that. One, obviously we urge the court to reverse, but I think that what the appropriate remedy would be if you didn't agree with us would depend on the reason you didn't agree with us. If you didn't agree with us because you thought that there was a problem with the substantial similarity language, then I think that the proper remedy would be, as we note in our briefs, would be severance and to indicate that the content and the formatting requirements were okay, but that the requirement that an institution use the optional model clause or a substantially similar requirement that the rule was vacated to that effect. The last point I would make is that I think
only on the substantially similar part of that. It would be okay to have the model clause.
Yes, they certainly could use the model clause, but the way that the rules are set up is it says use X clause or a substantially similar one. So you couldn't, if you just cut out substantially similar, then you'd be making the problem worse, actually.
So you may use X clause or otherwise comply.
Right, but I think that Judge Rao, your question about implementing the district court's judgment, I think gets at the indeterminacy of the district court's understanding of what counts as a mandatory clause, which I think is also reflected in PayPal's view. It's impossible to know what counts as a mandatory clause and under what circumstances. I think no matter what, there may be some kind of line drawing questions even on our approach, but I would suggest on the district court's approach and on PayPal's approach, there's no line at all, right? It's just a, kind of know it when you see it kind of inquiry. And I think that suggests why that approach is not the appropriate one for the court to take.
What do you understand the district court's order to have done? Because when it has the caveat that says insofar as there's mandatory, as I read the district court's decision, there's a sentence before that, and I just can't find the page in the joint appendix, but there's a sentence before that where the district court explains why what the Bureau did is mandatory. And that sentence encapsulates everything, content,
yes, which
led me to think then that what the district court meant by saying insofar as they're mandatory is it meant everything.
Yes, Your Honor, you
wouldn't have to reach that conclusion just based on the way the conclusion is worded, but when you piece it together with the prior sentence, that's the impression one is left with. But is that the assumption on which you're litigating the case, or do you have a different assumption?
That's our understanding, Your Honor. I think also if you note on footnote 9 on page JA86, the court says, because I vacate the short form disclosure requirements and another provision, I need not reach the other issues that were raised by PayPal. So I think that the court, although as you know, the conclusion is sort of pitched to the extent the district court's understanding was that basically any kind of mandatory requirement to do anything counted as a mandatory disclosure clause. I see that my time is up. I'd ask the court, if you have no further questions, to reverse the district court's judgment.
Thank you, Mr. Deal. We'll give you some time for a rebuttal. Mr. Shanmugam, we'll hear from you now.
Thank you, Chief Judge Srinivasan, and may it please the court. A requirement to issue optional clauses is not the same as an option to issue required clauses. When Congress gave the Bureau the obligation to issue model clauses for optional use, it foreclosed the power to issue clauses for mandatory use. And as Mr. Deal's argument this morning makes clear, the Bureau now seemingly concedes as much and instead makes a new argument that it did not make below. namely that Congress foreclosed it from mandating only the exact wording of disclosures. This court should reject that impossibly narrow interpretation. The Bureau's newfound litigation position here is inconsistent with its own use of the word clause, both in the prepaid rule and in the official commentary. And it would belie common sense to say that the prepaid rule does not impose mandatory disclosure clauses. The rule specifies the fees that may and may not be listed. It prescribes the words that may be used to describe those fees, and it prohibits explanations of those fees. And it closely regulates the ordering and the formatting of the required disclosures. The mere fact that an institution may use immaterial variations in wording does not alter the bottom line here. The Bureau has mandated a particular way of conveying particular content, and those are mandatory disclosure clauses by any measure. The judgment of the district court should therefore be affirmed.
If you say the Bureau has mandated a particular way of mandating a disclosure, then that seems to presuppose that the Bureau can mandate the disclosure. What we're talking about is the particular way in which it's being mandated. So that gets to wording as opposed to content.
Wording and formatting as well, in our view, Chief Judge Srinivasan, but I think we would concede that when it comes to the content of the disclosures, the Bureau obviously has some authority to do that. And that really stems from Section 1693C, which gives the Bureau the authority to mandate the substance of disclosures.
Right.
What we're really talking about here is the form or the manner of the disclosure. I want to go right to where you started, Chief Judge Srinivasan, with your question to my friend, Mr. Deal, because I think that that really illustrates kind of the point of difference between us here. Our view is at bottom that the fact that substantially similar language can be used to describe some of the fees doesn't render these clauses non-mandatory. But I want to emphasize one thing at the outset, which is that our objection here is not to the fact that we have chosen synonyms for ATM withdrawal fee that we can't use here. Our objection, though I would agree that there are a very limited number of synonyms that can be used for that. And if you look at the examples that the Bureau gives in its brief, I would submit that those examples don't seem to afford any sort of meaningful discretion. Our real objection here is to the fact that we are prescribed from providing any sort of explanation as to the fee itself. And this really goes to,
I'm sorry, Mr. Chairman, you are able to provide explanations in the long form, and you're able to reference the long form in the short form. But the nature of the beast is to have something, you know, of a digestible short length. So you have the speech opportunity everywhere else.
It is certainly true, Judge Pillard, that we have the ability outside the four corners of the short form disclosure to provide explanation. But to the extent that the Bureau points to that, it is in some sense at war with the Bureau's submission that its goal here is to focus the consumer on the short form disclosure, recognizing that consumers will not necessarily read anything outside the four corners of that disclosure. But I do think that this is a really important limitation, particularly for a company like PayPal. And let me provide an explanation that perhaps illustrates why. And this is obviously a counterfactual example, but hopefully it really underscores the problem here. Let's say that we actually, in fact, charged an ATM withdrawal fee, which, as you will see, at least from the product that is the example at page 14 of our brief, we don't. But let's say that we did. But let's say that we charged only $1 everywhere, but we charged $10 in Hawaii because of the additional transaction cost of doing business there. We would have to list $10 as the fee, and we would be disabled from explaining that that fee is only charged in Hawaii. And that really, I think, illustrates the prescriptive nature of these requirements here. It really is all about the fact that unlike the long form disclosure, where we are able to provide an explanation and where perversely the Bureau doesn't really require any sort of mandatory wording, we are very much constrained. And that's what makes this prescriptive and therefore mandatory.
The thing about it is, if the nature of that objection is, look, we have to disclose the highest fee that we charge anywhere, and we can't appropriately give it context so that consumers understand that that's an outlier. And really, we rarely ever charge a fee. And if we do, it's going to be a fraction of that. It seems to me that the problem with that is not necessarily that it's a mandatory clause in terms of its wording. It's that it's just arbitrary and capricious for us to be required to issue this narrow, misleading disclosure. And you have that challenge, and you may well have the opportunity to go forward on that challenge. But I'm not sure that that tells me that it's a mandatory clause in terms of its wording. The problem is the content of it.
Well, I take the point that there is an aspect of this that goes to whether or not this is arbitrary and capricious, Chief Judge Srinivasan. But I think my point for purposes of this colloquy is a more modest one. I really mean to just sort of underscore the prescriptive nature of what is going on here. And so to the extent that the Bureau now focuses myopically on the meaning of the word clause, I think it's important to keep in mind that what we're discussing here is whether these are model clauses for optional use or whether they are instead mandatory clauses. And I think my point, I would sort of go back to my first point, which is that, the mere fact that you can use immaterial variations in wording doesn't make something anything other than a mandatory clause. To sort of underscore this, let me give another example, if I may. Let's say that one of our teenagers went out and went joyriding, and I said to him afterwards, I want you to write 100 times, "I'm sorry for borrowing your car." I think that the fact that I gave him the ability to say, vehicle or SUV or some synonym for car wouldn't make those anything other than mandatory sentences. And so regardless of whether you define clause, narrowly to mean precise wording, or whether you give it a somewhat more expansive meaning, such as, just a way of providing particular content. And again, I think in context, that's a better understanding.
But
The
Mr.
key point.
Shanmugam, I'm sorry.
No, I was just going to say that the key point here, Judge Pillard, is that there is no meaningful discretion. These are not optional clauses under any ordinary understanding of that phrase.
What about putting it in the context of the disclosure requirement? It seems like, and I think Mr. Deal was saying this in his own way, that the substantial similarity, in a way, as Chief Judge Srinivasan's initial question pointed out, in a way, you don't even need that, because the disclosures are disclosures about topics, and the point of the disclosures is to allow comparison. And so the restriction really, the confines of the flexibility seem to me to flow less from the articulation that the disclosure should be substantially similar to the optional model clause for optional use, but rather from the nature of what it is to disclose something in a way that allows comparison. And nobody argues that the statute doesn't allow regulation requiring disclosure in a manner that enables reasonable comparison. So I guess obviously in the world that your clients would prefer, they wouldn't have to disclose and they could say it in any way they want, wherever they want, but they're not fighting the premise of the statute or the ability to regulate to fulfill its disclosure function. So going on too long, but isn't the narrowness, the substantial similarity really just baked into the statutory enterprise?
Well, I don't think so, Judge Pillard, though. I think I agree with a large part of what you've just said, in that my client obviously doesn't have any objection to the substantive requirement that, where, for instance, they charge fees for electronic fee transfers, they have to make disclosures. Again, as I said to Chief Judge Srinivasan, this really goes to, the manner or the form of the disclosures, and in our view, the statutory prohibition on mandating that. And so, as you say, Judge Pillard, we certainly recognize that with regard to the fees that we do charge, we have to make disclosures. We, of course, do make disclosures. We have no objection to the long form disclosure requirements, precisely because they don't mandate wording and they provide the flexibility to provide explanations for fees. But, to the extent that Mr. Deal makes the point that this regime is designed to facilitate comparisons, I guess I'm at a little bit of a loss as to what the statutory authority for that is, because the regime is premised on the notion of optionality and flexibility. It is designed to give institutions flexibility about the form of the disclosures, recognizing that there is a safe harbor, recognizing that if an institution complies with the model clauses that are set out by the Bureau, that it will be free of liability. And presumably, parenthetically, going forward on this issue of remedy, presumably that is still true today, which is to say that if a financial institution used the previously mandatory clauses, that would presumably constitute a safe harbor in the wake of the district court's remedy. And that's precisely how the statute is supposed to work here.
So, Mr. Chairman, would that give it does seem that many of your objections are to the content, right? The fact that there are certain things that must be disclosed. If we were to find that, say, the only problem was that the clauses in the rule are mandatory, and we were to somehow sever that, does that give your client the relief that it is seeking? Or is that just sort of a harmless error because the rule itself requires certain content to be disclosed? If we make the clauses non-mandatory, but of course, the other provisions are left in place, or maybe on remand, you have an opportunity to challenge those as arbitrary and capricious. But does that actually give you the relief that you're seeking?
I think it does, Judge Rao. And let me sort of say two things here. First, let me say something about the remedy. And then second, let me say something about the content requirements. On the question of the remedy, to the extent that Mr. Deal today seems to fault the district court for its remedy, and I would point the court to the district court's order at page JA 87, it invalidated the prepaid rule only to the extent that it provides mandatory disclosure clauses. The reason why the district court wasn't more specific about what that means is precisely because the Bureau didn't make any sort of argument to the district court about the precise meaning of the term clause. I would point the court to pages 21 to 28 of the Bureau's brief in support of its cross motion for summary judgment. You won't find this argument that clause simply means precise wording anywhere in the Bureau's brief. So I think the district court can hardly.
I think both sides didn't exactly define clause. What is your definition of what the clause is here? And what do you think Judge Leon's relief encompasses?
I think what Judge Leon's relief encompasses, Judge Pillard, to be very specific about this, is that Judge Leon effectively was saying that to the extent the short form disclosure requirements in 1005.18 are mandatory, that is invalid, that those requirements have to be optional. And in our view, that does include wording as well as ordering and formatting. And again, the reason that there was not, more macular litigation about this in the district court was because the Bureau did not advance the argument that it's advancing today. But to finish my answer to Judge Rao on the issue of content requirements, again, we have no objection to the Bureau mandating that specific fees be disclosed, subject only to the implicit limitations in section 1693C. That provision requires disclosure of fees regarding electronic fund transfers to the extent applicable. And I think that the Bureau itself in its own regulations, and I would point the court to the commentary on the regulation that implements that provision, it's 12 CFR 1005.7B5, makes clear that, other fees that don't relate to electronic fee transfers may but need not be disclosed. There might be issues concerning what fees the Bureau can mandate disclosure of. And in our view, if it's a fee that's not being charged, the Bureau can't mandate disclosure of that. But other than that, the Bureau has a great deal of discretion, again, as to content. Our objection here is purely to the form and the mandatory form that the Bureau required here. And the best evidence that the Bureau was imposing a requirement, a mandate, was that the Bureau said shall and not may here. And that's the fundamental problem with this new mandatory disclosure regime that the Bureau established.
Can I ask this as a follow-up to Judge Rao's question? So the part of the briefing takes issue with a substantial similarity limitation. If one were to assume just for purposes of argument, I'm not saying that this is a conclusion, but if one were to assume that cabining into substantial similarity is sufficiently close to imposing mandatory language that you carve out and excise the substantial similarity limitation, but otherwise leave the rule standing. Does that address a concern that you have, or does it not?
Well, it's not entirely clear to me how the court could go about doing that, because if you take a look at the relevant provisions of the short form disclosure requirements, each of those provisions requires the use of a particular term or a substantially similar term. So I think, actually just excising the substantially similar.
I'm not supposing that there's a magic red line that could be done that leaves an intact rule in its wake. I'm not sure that that has to be the case, by the way, but, and I could be persuaded otherwise, but I think what I'm getting at is just ultimately the substantive conclusion, as opposed to the actual redlining of the provision, would be eliminate the substantial similarity limitation, but otherwise leave the regulation in effect.
Yeah, and I guess what I'm struggling with, Chief Judge Srinivasan, is that I'm not sure exactly how that regime would operate in practice, which is to say, if all you're basically saying is you have a greater degree of discretion to use, synonyms when describing the fees, I think we would say that that still is a mandatory regime, because of the limitations on explanation and the other prescriptive aspects of the rule. So I think, frankly, the simplest solution here is to simply say this regime is now an optional regime. But of course, if the Bureau wants to come back with more modest requirements, if the Bureau wants to come back with requirements that simply specify font size, I don't think that we would have the same objection to that. And I think that the district court's remedy here actually gives the Bureau some degree of discretion to do that if that's what the Bureau wants to do. What the Bureau can't do is to mandate the language and also, along with that, to impose limitations on ordering and the like.
I mean, Mr. Shamgan, surely you agree that the EFTA gives the Bureau authority to impose disclosure requirements that are greater than font sizes. I mean, with respect to content.
If the Bureau, for instance, going back to our earlier discussion, Judge Rao, if the Bureau wants to specify that there have to be disclosures about particular fees that are charged in connection with electronic fund transfers, sure, the Bureau could do that. That would be an exercise of its authority to implement 1693C.
And that they'd have to be done in a particular font size.
Sure, I think that would be fine too. In our view, as long as the Bureau as long as an institution has the ability to provide an explanation as to the fee that it's charging, and as long as the Bureau is not mandating the use of particular language, I think that would be fine. And all of that would be consistent with the statutory limitation that we're talking about here, which is the prohibition on the Bureau's promulgating clauses for mandatory use as opposed to model clauses for optional use.
Mr. Chairman, why isn't in the regulation in B2, where it says that a financial institution shall provide a disclosure, and then it says as applicable? Why doesn't that allow PayPal to choose which of these disclosure requirements are applicable?
So I don't know which as applicable you're looking at.
So I guess in 1005.18 B2, which is which is really like the preface to many of these disclosure requirements.
Yes, no, I see the reference that you're pointing to. And so, I think that the fundamental problem with that is that the Bureau has made clear that all of these items in the so-called static portion of the disclosure have to be included. And indeed, if you look later in 1005.18b, it makes clear the order in which they have to be disclosed. The only ability that an entity has here, if it's not charging a fee, is to list NA, as indeed PayPal did with a number of the fees, if you take a look at our disclosure at page 14 of our brief. And, I think one of the problems with that is the very real risk of consumer confusion. And while this is outside the administrative record, we point out in our brief that that was a very real risk that was realized when consumers suddenly were confronted with a disclosure that listed this panoply of fees, many of which are inapplicable in the context of digital wallets. And that obviously goes outside the context of this particular statutory challenge, but it in large part explains why we're here.
In some ways, your objection is to the supplement, to like the interpretation that the Bureau further specifies that even when a particular feature is free or is not applicable, you still have to provide these disclosures.
Yes, I think that the supplement makes that clear, Judge Rao, but I think that that's also pretty clear from the ordering requirements themselves in the rule.
The evidence of confusion is not in the administrative record, but in your complaint.
Yes, that's right. And I don't think that we, sort of need that for purposes of this statutory argument, Judge Pillard. I think that the risk of confusion goes to the constitutional avoidance argument, which we make. But of course, our frontline submission is that the statute is really unambiguous in all relevant respects here, and particularly in light of the Bureau's concession that it is precluded from promulgating mandatory clauses. I'm not sure that there's really a lot of meaningful disagreement left on that score.
Okay, thank you, Mr. Shanmugam. Let me make sure my colleagues don't have additional questions for you.
Thank you, Your Honors.
Thank you. Well, Mr. Deal, we'll give you 3 minutes back for your rebuttal.
Thank you, Your Honor. A few points. I think one important thing to note here is that my friend Mr. Shanmugam didn't provide a definition for you to use to understand what a clause is, and suggested that we were being sort of myopic in focusing on the word clause. But I think clause is really the critical distinction between the parties' positions here. Through the course of the litigation, the issues have clarified, and as the court has noted, the Bureau clearly has the authority to issue mandatory disclosure requirements. We're not disputing for purposes of this case that we can't do mandatory clauses. So the question is, what's the difference between a mandatory disclosure requirement, which we can do, and what's a mandatory clause that we're not saying that that we're not disputing that we cannot do?
Well, what I take Mr. Shanmugam to be saying is, what it seems to me that he is most objecting to is that there are certain mandatory clauses that have to be used even when they are not applicable to a particular financial institution. So in what sense? So like if you have to use certain language that just doesn't apply to your product, why is that not, why is that within the Bureau's authority?
Well, the Bureau doesn't require to use particular language to talk about your product. What it says is you need to tell consumers what fee you charge, what the amount of the fee you charge is, and maybe that you charge $0. That's still applicable to your product. And I think it's helpful for consumers to understand, to the extent you don't offer a particular service, that you don't offer it. And so that therefore that's not applicable. I think that making clear to consumers, here are, I think the important context here is that these are the fees that the Bureau picked are what the Bureau considered to be the most important, the most common fees that prepaid accounts contain. And that's like sort of across the board for prepaid accounts. And so the Bureau said, you need to tell consumers basically what the situation is with respect to each of these fees, with respect to each of these services. But you can use either the language to describe that, you can use the language that the Bureau has identified, or you can use any other substantially similar language.
Is that flexibility meaningful though, where an institution just simply doesn't provide for that service or charge that fee?
There is flexibility with respect to the language, but there is not flexibility with respect to the content requirement. That's the balance that Congress struck here. It gave the Bureau the authority to require particular information, particular content that be prescribed, that institutions had to provide, while at the same time providing this optional model clause provision with respect to language. And we think that the Bureau's rule meets that combination. I see. Oh, sorry.
One point that came up a couple of times in the course of Mr. Shanmugam's argument is the prescription about order. And can you just give your response on the Bureau's view as to why prescribing the order in which things are laid out doesn't verge on wording as opposed to content?
Well, I think it doesn't match the word clause at all. You could have a series of mandatory clauses and say you can put them in any order you want. That'd be a series of mandatory clauses. The fact that you need to provide information in a particular order, this piece of information, then this piece of information, then that piece of information, I don't think doesn't suggest that there's anything other than optional model clauses that are.
Well, I take it that the point would be that then each one of those pieces of information is not a separate clause. It's that the entire thing is a mandatory clause because it's prescribing the order in which sub-aspects have to be disclosed.
Your Honor, I don't think that there's any sort of textual basis for saying that ordering is what Congress was concerned about with respect to the optional model clause provision. The statute is focused, both in that optional model clause provision and in 1693C on readily understandable language. That's the goal. And so any kind of ordering requirement has really nothing to do with the Bureau's obligation. Again, we're talking about here is an assumption based on the obligation to issue optional model clauses. And so in order for something that the Bureau did to exceed its authority, it needs to be inconsistent with that. It needs to conflict with that. And I don't think that any requirement with respect to the ordering of providing the information is in any way inconsistent with the obligation to issue optional model clauses.
Okay, I just wanted to give you a chance to respond to that since it came up. Judge Pillard, did you have a question?
I was just going to ask whether if the rule, and I recognize it's counterfactual, and I recognize we're not, in the business of redrafting, but just to sort of understand the nature of your position, if the rule required disclosures under Romanet 3, for example, of a periodic fee. It currently says the periodic fee charged for holding the prepaid account assessed on a monthly or other periodic basis using the term monthly fee, annual fee, or substantially similar term. Would the Bureau be achieving its objective just as much if it said disclosures required the periodic fee charged for holding a prepaid account assessed on a monthly or other periodic basis, period? The term monthly fee or annual fee are deemed compliant. That's your optional model clause. But a substantially similar term may also be used. That wouldn't depart in any way from what you're trying to achieve.
I think that would be, if I'm understanding your hypothetical correctly, Judge Pillard, I think that is what the Bureau did, in other words.
And what if we said in the end, instead of but a substantially similar term may also be used, but other terms that are readily understandable or fully, accurately, and effectively disclose the information may also be used?
I mean, I think there may be some slight difference there. I think that that wouldn't. The Bureau chose substantially similar, and I don't want to give up that choice. I think that helps everyone, ensure that there's a similarity between the forms, which I think is an important goal. But I think that the way that you have proposed rewriting it would achieve very similar results. Substantially similar results, perhaps.
Thank you.
If there are no further questions, we ask the court to reverse the district court's judgment.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Friday, February 11th at 9:30 a.m.